They didn't beat you in court. They just made you too broke to show up. Bankruptcy! The weapon with a legal name. Statutory demand, 14 days to pay. You can't, so the application goes its way. Not because you owe, but because they want you gone. Wind you up before the case can carry on. It's cheaper than a hearing, cheaper than a trial. Just bankrupt the opponent and deny the file. The credit is petition, perfectly legal art. A weapon in the hands of those who play the part. It's not about the debt, it's about the silence. Make them insolvent before they build the alliance. Bankruptcy weapon, pointed at the truth. Bankruptcy weapon, aimed at the proof. They pulled the trigger not to recover funds, but to make you disappear before the hearing comes. By the fair go movement. Respondent A served the demand 48 hours before the hearing on their misconduct, the one they couldn't ignore. Now respondent B is insolvent, can't fund the fight. Trustee in bankruptcy owns the right to decide whether to pursue or let it lie. And guess who's from the trustee used to work beside? The litigation dies, the misconduct breeds. Bankruptcy, the weapon no one sees. It's not about the debt, it's about the silence. Make them insolvent before they build the alliance. Bankruptcy weapon, pointed at the truth. Bankruptcy weapon, aimed at the proof. They pulled the trigger not to recover funds, but to make you disappear before the hearing comes. By the fair go movement. We need insolvency law reform, targeted use review. We need a watchdog that can see when the weapon's being used to pursue. We need evidence integrity protocols to preserve the claim. When bankruptcy is weaponized, the evidence must remain. Litigation funders, public trustees, independent review. Because a debt instrument shouldn't silence what is true. I've tracked the pattern, case by case. Demand served within days of the hearing date, not coincidence. A strategy of play, make them insolvent. Watch the case decay, and when the trustee folds the claim, they walk. The misconduct never proved, just buried in the talk. But the documents survive, the trail is there. Bankruptcy weapon, we know where you were. Bankruptcy weapon, pointed at the truth. Bankruptcy weapon, aimed at the proof. They pulled the trigger not to recover funds, but to make you disappear before the hearing comes. By the fair go movement. We will not be wound up, we will not be silenced by a statutory demand dressed in legal compliance. Reform the weapon, regulate the use, because insolvency law should never be a